Most people would recognize that if you start smacking a kid to tell them not to be violent, you're in fact reinforcing the very message that you're saying you're trying to interrupt. And so, you know, the old adage of, you know, that it was used in capital punishment, and when we're trying to make sure capital punishment didn't return, why kill someone who kills someone to show that killing people is wrong? Well, similarly, why do you punish people who've done something which they arguably have not had a whole lot of ability to influence the state or the situations they're in, where they have? Punishing them for it is not likely to change that behavior. It may change how they try to hide that behavior in the future, but if you don't actually set up a process whereby they can have an ability to do something different in the future, then all you do is teach them to be, you know, not get caught at it next time or something like that. So I think that when we talk about the principles, we have to think about the reality of who's in prison in the first place. And too often, whether it's restorative justice, sentencing, criminal law, we don't talk about pulling back a bit and saying, why is it we even use these processes? Crime is a theory. What we choose to criminalize and what we choose not to criminalize depends on who's in power and who has the authority to make those decisions. So when you recognize crime's a theory, you have a whole lot of leeway to determine what you'll criminalize and what you won't, and we don't even have those discussions in terms of, we end up talking about tinkering with those who were, you know, we just continue to decide we'll catch or criminalize more things, or we'll norm crime. You know, even when we talk about crime prevention, that's norming crime. You know, I used the example today in our session of when you have food programs, when you feed kids in schools and say it's crime prevention monies, what you're essentially saying is, I'm feeding you kids so you don't become young criminals. What kind of message does that send as a society when we fund things and call it crime prevention? It means we norm crime, instead of saying, as Louise Arbour said a few years ago, why aren't we now talking about human rights as basic rights to be free from want? I mean, what a concept, that we as Canadians return to a notion, or maybe claim a notion, if it's arguable about whether we had the notion, but internationally we like to tout ourselves as great defenders of human rights. And if we have a notion that human rights means freedom from want, that sets up a whole new landscape of how we start talking about, you know, social services, healthcare, education, community development. It doesn't even put crime in the landscape. Doesn't put prisons in the landscape, doesn't put criminal law in the landscape. It starts out by saying every child who is born is entitled to be fed, clothed, housed, educated, self-actualize, be the best that they can be, and do whatever they can do to contribute, and modeling that behavior, not starting by saying, we're going to feed you so you don't commit crime. We're going to feed your mother so you don't commit crime. We're going to get you educated and give you a Head Start program because we don't want you committing crimes. So, you know, all of those sorts of things. Those are the messages we send implicitly, even when we're trying to do it in a benevolent, progressive, kind-hearted, restorative, transformative, however people want to talk about it. The minute we start to go back to norming justice, or norming criminalization, or norming prison or crime prevention, or any of those, then we start off by sending the wrong messages, I think. Not everything that we choose to criminalize gets reported, because it depends on in whose interest it is to, one, label something a crime, and then in whose interest it is to criminalize certain individuals in certain contexts when they've done certain things to certain other people. So, you know, you have to look at the layers of privilege and opportunity and lack thereof to see, you know, where it's likely and where it's least likely and where it's most likely that'll be where something will be criminalized. Because many people would say, oh yeah, homicide is almost always criminalized. Mm-hmm. Not true. Why do we have, what I was just writing up there was for the missing and murdered Aboriginal women. Why do we even have a situation where Indigenous women go missing every day in this country? And even when they're reported, there's virtually no attention paid to it. So you're saying that's not a crime? That is a crime not in the vernacular and in what is defined as criminal. And yet, in whose interest is it not to focus on the incredible tragedy and incredible loss in Aboriginal communities of the victimization of Aboriginal women and children in particular, men too, but particularly women and children, the fact that they go missing and are murdered, and there's virtually no attention paid to it. Whereas, think of the message it sends to those women when a white woman may disappear from a wealthier community or even a middle-class community, and her face is on the front page. Everybody's looking for who may have, and at the same day, and this has happened in virtually every community where this kind of situation has occurred, Aboriginal women have gone missing, and there's been virtually no attention paid. You know, in whose interest is it that that's how it's dealt with? I mean, one of the courses that I'm, have had the opportunity to be working on and develop at the University of Ottawa Law School is one called Defending Battered Women on Trial. Part of the reason we're doing it is because it's been driving me out of my ever-loving mind as I started with E. Fry working on the post-Lavallee. So Lavallee was a case in 1990 where a woman, for the first time, was able to use self-defense in a context where she shot her common law partner in the back of the head as he was leaving a room. So usually not seen as self-defense, because the law of self-defense, remembering in whose interests they're developed, was built up at a time when women and children had no rights. Women and children were the property of the men who sired them or married them. So the men who were their fathers or who married them. And so at that time the law of self-defense developed. Well, who was the law of self-defense designed to defend? Men. In what context? Mostly barroom brawls. So the notion of self-defense came that it has to be force on force. Is it a reasonable reaction to force? So when Angelique Lavallee's partner tossed her the gun and said, "You better shoot me, and when I come back, I'm shooting you," she understood that to be a very real threat. She understood that if she picked the gun up as he was standing in front of her, it might very well be grabbed out of her hand and be used to kill her. And she understood that the only way to defend herself was to shoot him as he walked away, because the minute he came back, that her life would be threatened. Every woman who hears that story understands that threat. Some men do. Every man who's abused a woman understands that threat. But and every jury who has had the opportunity to hear out those stories has acquitted. What's a shocking reality is how few women actually go to trial in those cases. And when I started in the work, we wanted to review the cases of women who had been jailed for defending themselves against abusive partners, because we knew there were a number in prison. In fact, we came up with 27 women. So we petitioned, got all the women's groups together, petitioned the government, said, you've got to review these cases. They finally agreed to, and we asked them to do a review like Mr. Justice Leggett did. Mr. Justice Leggett from this region did when a whole bunch of men petitioned the government to review the habitual offender provisions, which were deemed to be just as unfair as the lack of application of self-defense to women, but had only been applied to men. The people who petitioned demanded individual counsel, an individualized process, but a group look at the area. So we thought, great, what a great model. Worked in that context. We asked for the same. We didn't ask, we demanded the same model. So we were seen first as strident women, stepping out of the norm, socially constructed norm we're supposed to fit in. And we could not convince anybody to provide individual counsel to those women. Instead, what did they get? 4 counsel for 108 cases. And of the cases that got recommended for any kind of review of their sentence, only 7. Of those 7, I can tell you, 5 of them were ones who I was working with the individual women and saying, have you told Judge Ratushny and her team this? Have you told them that? And some of them were initially, on the first round, turned away and said, no, your case doesn't fit. And had I not known their cases, and others who were assisting as well, to send back and review them, then they wouldn't have been reviewed further. And the point of that is that in the habitual offender review, a very effective review was to knock out, most people don't even know there was ever a habitual offender provision. It's gone now. And most of the men who had been bitched, as was a term was used, we won't go into the misogynistic, anyway, we won't go into that. But the majority of the men, it was overturned. Some of them still remained in jail because they had committed very serious offenses. Some were released, and some had new trials and new new approaches. Everyone had their own counsel. And some of them very, very senior counsel, and that was all funded by the state. In the self-defense review in the 90s, it was a more junior judge. She did a very good job. 4 lawyers. They did a decent job too, but there are 4 lawyers trying to handle each of them, about 25, 26, 27 cases. And out of that, nobody got out of jail. 1 woman got her life sentence commuted to time served. And what Judge Rotushny found that's relevant to this is that there were probably about 30 cases she thought should be reviewed, but they had pled guilty. They had pled guilty because they were told they probably wouldn't have a defense, or the lawyer didn't think their prior history of abuse was relevant because it wasn't abuse that was happening right then, and so even though that information was available, it wasn't used, so they can't use that to reopen the case. Or the women would say the only witnesses to the abuse were their children, and they didn't want their children having to be dragged through the system and take the stand to testify to the abuse. So what does that have to do with what we're talking about? Well, in that context, what's criminal? What's criminal is the lack of the ability to have the application of current law of self-defense meet at all the reality of those women. It gets worse because then we said, okay, well, we'll start working on these individual cases. And just a few years ago, part of the reason we developed the course, and we're working with Native Women's Association on this whole notion of hyper-responsibilization of Aboriginal women, is there was a case that a woman had killed her nephew, actually. Was charged with killing her nephew on a reserve in Manitoba. And by the time I was asked to be involved, she had already indicated she wanted to plead guilty, and the police said there was a statement anyway. She'd indicated she was guilty. So I don't usually work on something unless I meet the person and get to talk to them and talk about it. So everybody was out doing some motions thing or some court application. I can't remember now what it was. So it was to do with the case. And I was sitting with the woman talking over a table like this. We were having tea. And we started talking about what had happened. And as she was talking, I said, "It doesn't sound like you did it." And she said, "No, I didn't do it." I said, "Well, everybody's saying you said you did it." "No, I didn't say I did it." I said, "Well, what did you say?" She said, "I don't know." And I said, "Well, why does everybody think?" I don't know. And so I started to think of every which way someone could say you're guilty. So I said, sometimes people will say, I went through a whole, that you did it, that you tried to do it, that you didn't stop it. Went through all this. And finally I said, sometimes women will say they feel responsible. She goes, "I am responsible." I said, "Well, why are you responsible?" She said, "Well, he was my nephew. I raised him. The day he came over, I gave him a drink, and I knew he wouldn't just take one drink, he'd keep drinking. I knew if he got drunk, he might get violent. And I knew that his common-law wife was going to tell him that night that the daughter that he loved and believed was his wasn't his. And that might send him over the deep end. So it was my responsibility. I am responsible." And I said, "Well, that doesn't mean, if you didn't stab him, it doesn't make you responsible." I said, "Well, so I then tried to say what happened. When we finally saw the police tape, the police officer said to her, "You're responsible, aren't you?" So he didn't say her name. And she said, "Yeah." And on that basis, some of the best criminal lawyers in this country, some of the best academics in this country on issues of criminalized women, had all proceeded down the path of, she did it. And what it told me and reminded me of is that we don't often explore all of that. The other thing that happened in that case was then we went back, I hate to even use the word case, but I don't want to use her name to expose, but when we went back and looked at what had happened, nobody had paid attention to, cops were called twice. And I said, "Look, cops were called twice." And they said, "Yeah." I said, "Doesn't anybody ask why the cops were called twice?" And, I knew why the cops were called twice, because the first time the cops were called is because the nephew was beating on his wife, and then on his aunt, who was eventually did still plead guilty. She didn't want to go through, she was taken off her reserve, taken out of her community, had to stay for a year. The man who actually, we believe, did it kept threatening her. His family was the family in charge in the community, and a whole bunch of complications. But nevertheless, nobody had even questioned, why did they even have to call the cops twice? Because the first time they called, it was because a woman was being beaten. The second time they called is because someone was dead. That's when the cops came. And I don't know if they would have come if they said the woman's dead. I hope and presume they would have at some point. But those are realities that make me question, even when we have something that almost everybody would say it's pretty clear that's a crime, and everybody recognizes it. So we developed the course, and the course goes through the social entrapment of women in violent situations, the community entrapment of women, so the familial, the social community, and then the legal entrapment of women. So that what happens when women call, we go through countercharging, all of those sorts of things. But one of the cases we talk about is Gladue. Most law students by then have, because it's an upper year course, have learned Gladue as a sentencing decision. But if you go back and read the preliminary inquiry, you realize how little of Gladue actually gets through in the end. It's become a sentencing decision for men. Very few women will you hear Gladue mentioned. Yet Jamie Gladue was a woman. Jamie Gladue was a woman who was being beaten. Jamie Gladue, when you read the sentencing decision, sounds like a jealous woman who went after her partner and killed him because he was flirting with her sister. When you read the prelim, that Jamie Gladue's partner climbed in the window of her sister's apartment, raped her, then came out. Her father testifies, and every Aboriginal witness who testifies is belittled by the Crown and they attempt to diminish them as individuals. Every non-Aboriginal person who testifies, their credibility is never questioned. And the construction of this woman as a violent, dangerous, drunken, jealous woman is never, ever challenged. So it's a great sentencing decision in some respects for Aboriginal people, but it's a terrible one when you realize as you go through and I don't know Jamie Gladue. I would imagine there's even more to that story if I met her. Just by the sentencing decision, as her father is on the stand and talks about how concerned they were about what this man was doing to the other children and why he never wanted to leave any of his daughters alone with them. You get a very strong picture very quickly of what the other subtext of that story is that never gets told in the Gladue decision. And so our students read it and are shocked that this decision that they think of as an important sentencing decision is a whole nother subtext about further treating Aboriginal women in particular in a misogynist, racist way. And so the fact that the violence she experiences, her victimization is almost erased in that. And in fact, some of the law students don't even know it's a woman. They don't read the facts of the case and just read the decision. They don't actually know that I can't imagine how you could not, because the context is there in the decision, but some of them either forget or don't know or don't care, I don't know. But so I think one of the things we have to re-examine is what gets criminalized and why is very much a function of who has the authority and the privilege to define that. So I'm not suggesting people are intentionally going and being racist and misogynist, but so much, unless we challenge those underlying concepts, a Gladue decision is just adding another layer on top. So for those who are already naysayers, here's a new way to give Aboriginal people a new justice system.
Doesn't it apply to all of us, though?
Well, it does, but what you're talking about in terms of a Gladue report is essentially what should be in a pre-sentence report for most people. That's right. But again, I would say that those are considerations that should be in place long before, and that when we rely on the criminal justice system to do that job, that's where we start making the mistakes. You know what I mean? That if we haven't laid the groundwork ahead of time to have healthy communities, thriving communities, individuals supported and able to live in communities. When we have, I keep saying 138 because that's the last figure, I think it's actually higher now, Aboriginal communities without drinkable water in this country. I mean, when we have the United Nations saying that the living conditions on most reserves in Canada are worse than most third world or developing countries, as they frame it, you know, how do we even start to talk about fair justice? We haven't got fair social conditions to start with, fair economic conditions, fair environmental conditions, fair anything. So, you know, I don't mean to I mean, I think the Gladue types of decisions are trying to fix things that can't be fixed by the criminal justice system way long after the fact, and contribute to people's racist attitudes, in my opinion. I know that's not the intention, but when you say a Gladue report, you'll see people within the system think, oh yeah, that's a special thing for, or a circle sentencing, or a circle hearing. Oh yeah, that's a special, more lenient. It's nonsense. That it's intended to be trying to balance the inequity that precedes. But because we aren't really fundamentally addressing the beginning stages of discrimination and you know, that happens when you can oppress people, then we're not addressing either further down the line. We're just adding another Band-Aid there, another Band-Aid here, another Band-Aid there. And you know, we're not really trying to address the festering problem that we have. I mean, think of how the law of children's issues developed. When we first started, before we had the Juvenile Delinquents Act, and you know, rather privileged white women were concerned about the waifs in the street during, you know, post-industrial or sort of part of the Industrial Revolution, concerned about all these poor wayward children. Well, the only way they could actually protect the children or get the children off the street was to use animal cruelty laws. Yeah, there were animal cruelty laws. Why? Because men had to be able to have their property, their livestock protected. Their, you know, so that's how we first had child protection legislation. It was animal cruelty laws were used. And then, of course, then we had child protection legislation. Then you realize, so if you can't protect those children, they become bad and start attack. Well, then we wanted youth criminal legislation, because we could either put them right into the adult system or we have to have something in between. So I don't mean to be flippant about some of that, but I think too often if we rely on the lawyers to solve it, it won't. And I think we look for quick solutions, and I think these are, if we really want to change, we've got to change fundamentally, you know. So, and I think we can do that in incremental ways, but it's not about putting a new Band-Aid here and there. It is about fundamentally changing how we all do what we do. So, for instance, if the police officers who called me a couple of months ago from Nova Scotia, because they had a woman that they knew I knew well in the car, and they had just driven her to the second psychiatric hospital, and they wouldn't take her. If they were commended for doing that, instead of for getting, you know, this arrest or 10 tickets or whatever, but if every time they took the extra effort to do something to try and prevent someone from ending up in more harm's way or hurting somebody else, usually it's hurting themselves, or hurting somebody else, or trying to get them the appropriate services, and they were commended every time they did that. They were commended for having no arrests, but people feel in the community and feeling more part of the community. If wardens were commended every time they had, you know, 10 grievances that were dealt with and resolved, and, you know, people released, you know, if they got raises based on the number of people they successfully released to the community, think how different the system would look. And I don't, you know, and I think a lot of people might say, oh, that's way too out there, but I don't think it is. I think if you said to judges, the fewer jail beds you use, the higher we'll make your pay, or you can contribute it to some other way to the community or whatever, something that is seen as a value to them. I think there's a responsibility we all have to take, but I think the notion of having to deputize individuals instead of requiring the state to be responsible. I mean, when you talk about unions, well, look at the hoopla that's been created by 4 guards being charged, 4 correctional staff being charged in relation to the death of Ashley Smith. Do you see the guards union calling for accountability, not criminalizing? I mean, they are, but they're not calling for across the board, just for their own. And that, you know, so I think your notion of the community being responsible is a good one. The problem is, right now we've had an increased intrusion of the state in terms of surveillance, encroachment on rights, all of those, and a retreat of the state in terms of support, whether that's healthcare, social services, education. So we're having an intrusion of the state, a retreat of the state. Well, guess what? Who gets clamped down? And then the expectation is, as we're withdrawing those resources, community, you're responsible. So who does that really fall down to? Again, those with the least. Instead of saying, state, you're responsible to not retreat. In fact, you're responsible to re-inject resources into those areas. And yeah, maybe retract a bit in terms of the encroachment of rights, the surveillance, and provide more resources. And then maybe we'd see a very different response.